It's time for Criminal Law 101
with criminal defense attorney Ken Eulo from the law firm of Smith Eulo
on 101.1 WJRR.
All right, Ken, what do you say, man? How are you?
Morning, guys. How we doing today?
Ready to, get into this Monday and see what it brings us. That's all you can do, right?
Yeah.
Taco, you've taken some questions in at 22526. Ken, of course, is a criminal defense attorney, so he is very well versed in criminal law and is equipped to answer or give a little bit of guidance on criminal law-related questions.
Yeah, he's done criminal law, like almost 20 years, basically.
Yeah, a little over 16 now at this point.
Yep.
22526 is the text line if you got something you want to send over. If we don't get to it today, we'll put it in the stack for next time. There are a couple things in the news I want to get your perspective on. Did you want to throw a question at him first, Taco?
Yeah, okay. There you go. If you need to get in touch with Ken directly, Ken at smithandeulo.com. That's EULO.com.
Great firm, by the way, and they run the gamut of criminal defense. It can be from a criminal traffic situation to first-degree murder. They've been there, done all of that defense work.
Absolutely.
If you go to smithandeulo.com, if you go there, you can just find Ken on there as well. Can a judge submit evidence during a hearing that the defense and prosecutor had no knowledge of said evidence prior to the judge submitting it?
So, I mean, obviously the judge is supposed to be a neutral arbiter, right? They're the person that's supposed to be kind of judging the whole thing. And, a judge kind of going out and arguing for one side by introducing evidence and trying to make argument that helps one side would kind of violate that neutral arbiter situation. So, I mean, the kind of general context where the question's written, I'd like to know a more specific example of it, but from a general principle, that would, show impartiality, a lack of that, in terms of, deciding an issue, right? Have you ever been in the midst of a trial and you feel like the judge just has it in for you? Absolutely. Yeah. I've experienced that, and I'm not going to name names.
No, definitely don't.
I wish I could, right?
Speaking of naming names, hold on to that thought for a second because I get a question on that. But
yes, and I'll tell you the county, but I was in a very serious capital sex case up in Marion County, not telling the judge or anything like that, but throughout the entire case, the judge would constantly make objections for the state, would, counsel, that's not appropriate, and you're not going to do that in this courtroom, and there's going to be an objection, and didn't do any of that for the state attorney's case, right? That was just solely, and we actually ended up getting a not guilty on that case because I genuinely believe the client did not do it. There was a whole revelation where, they asked for, like, tattoos. The victim described tattoos.
Was it a jury trial?
It was a jury trial.
Okay, all right.
But, I mean, the judge right in front of the jury, right in front of everybody was just saying whatever came to his mind.
So the jury probably got the same kind of impression, you're thinking, maybe, so...
Yeah, I mean, we had to have a couple of bench conferences where I said, Judge, listen, this is not appropriate. Like, if the state wants to make an objection, you can rule on that, but you should not be interjecting yourself into this.
It's not appropriate.
Yeah.
Yeah. And speaking of judges, certain judges, and that they're either you want to be in front of them or you don't.
100%. Yeah, there's definitely, judges have different backgrounds, right? Like, you got judges that are coming from, the prosecution. You got judges that are coming from the defense side of things. I think the best judges are ones that have kind of a mix of both of those backgrounds because they can see from both sides of the coin.
Mm-hmm.
Have you done both sides of the coin?
I have not. No, I've been in defense my entire career.
Okay. Right.
But we have a lot of people at our firm that do have both. They came from the prosecution office and they came over to...
Good to have that perspective as to how they approach things.
Here's another quick question. Plain smell searches of cars. I'm hearing that it's not allowed in Florida. In some areas now. Is that true or not?
Yeah, that's actually a huge development over the last year where the smell alone of marijuana is no longer allowed to be the sole basis for a search. Now, there's some context to that, right? It can be one of the factors, right? So if an officer sees somebody and they smell, and they see some sort of other evidence of criminal activity that they can mix with the smell, then they can kind of bundle different factors together to create probable cause or reasonable suspicion for a stop.
But they cannot just I smell weed. They cannot just search the car.
Correct.
You blow a red light right through it.
Yes.
Police officer pulls you over. You also are smoking weed. And now the officer has pulled you over for blasting the red light, but now he's walking up to your car and can still smell the weed. So is that a case where he can expand upon that or no?
In said scenario, Pat, does he have a doobie hanging from his lips?
No, seriously.
Yeah, so I need more. So, obviously you have the traffic infraction, right?
Yeah.
And if the person, if the officer comes up to you and they smell what appears to be fresh, cannabis, that was probably just smoked or some sort of burnt, then I think that there's some sort of, I would venture a guess that maybe there's some evidence of a DUI there. So I think getting somebody out of the car, doing field sobriety tests, potentially searching, would make a lot of sense. But again, all of these fact patterns are kind of making their way through the court system now,
right?
Because it's pretty new. I mean, for as long as I can remember, the idea that you could just smell of weed was allowed, and then these cases came out that said it can be a factor, but it can't be the factor. So they're fleshing out.
Well, now you can't get to a stoplight without smelling it.
Oh no!
Right? Yeah. So, but I think in the context of driving a car, it makes some sense that they would say, "Hey, you're driving a vehicle. If there's a fresh joint in the car, that would show that you're potentially under the influence."
Right.
So I think that is a stronger case for a cop to make the search in that situation.
I want to ask you about the term "person of interest." We're seeing this right now in a huge story from the weekend involving the shooting at Brown University in Rhode Island. 2 students are dead, shot during finals preparations. Multiple others in the hospital. Terrible. So as the university went on the lockdown, they were looking for the suspect or suspects. Along comes, they show some video of this person of interest. Then we come to find out person of interest is in custody. Name of person of interest is leaked, and several media outlets report person's name. Person is then released in the overnight hours, saying, no, we're going in a different direction. This isn't...
it's not our person.
How do you unring that bell if you're that person of interest who... the grave mistake you made was walking down the street and being caught on the camera at close proximity to where something terrible just happened.
Yeah, right. So, like, in terms of what are the damages? Like, I guess that's kind of what you're getting at, right? Like, what is what can the person do to unring that bell? I mean, it's not really like defamation per se, right? Because they're not actually lying. They're just saying, hey, it's a person of interest, and it was a person of interest. So there's not like an intentional misrepresentation of fact there, right? I mean, if they had said, hey, this is the guy that committed the murder, and they arrested that person, then you'd have a different kind of analysis. But
you know how Bob protects himself against such scenarios like that?
No.
One word.
Alleged. Alleged is a very good word.
He puts alleged in front of everything that he's unsure of, and he's like, I'm covered.
Yeah.
Lawyers do the same thing.
Yes,
I think it's a smart move.
Exactly.
See, that's the law.
Exactly.
That's the law part of my brain.
Yes.
10% lawyer here.
Yeah, no, it's a smart move for sure.
All right. And then one other thing, another story that's, kind of got pushed out of the headlines, but is still important nonetheless. The guy who is accused of murdering Charlie Kirk, the judge out in Utah, is currently weighing the amount of access that he's going to give to the media and or cameras potentially into the courtroom. How tightly can a judge control the flow of information and access to legal proceedings?
Yeah, so you have the Constitution that kind of lays out a whole list of different kind of little clauses that talks about the right to an open trial and the right. I mean, so the idea is, I'm not sure if how far you want to dig on this, but you have like the Star Chamber back in England, right, which is where we kind of came from, where we said, hey, we don't want these secretive hearings.
Tribunals or whatever they would call them.
Where like you're deciding a person's entire life and nobody even knows what's going on. So we created a system that's a little bit more open, a little bit more, it's the goal is to have everything out in the open. So there's no secretive stuff going on. People aren't getting, these crazy sentences behind thing. That being said, there's also a judge's job and a judge's obligation to make sure that the person gets a fair trial, and a trial that's not, really basically everybody has certain information.
Turns into a circus.
It turns into a circus.
But we see that time and time again with, you look no further than OJ as an example. Casey Anthony, perfect example.
So it's really just going to be a discretionary determination by the judge. I mean, the judge has a lot of discretion to say, hey, can we do this in a way that's clean? How long is this trial going to last?
Yeah.
Do I have the ability to kind of set up the courtroom in a clean way where it's not going to interfere with anything?
He's talking about camera angles and stuff like
Correct.
that. So he ultimately said he's going to come back with his final decision in February before the trial gets going. But it's interesting.
Yeah, it is. I mean, but the judge, these have a ton of discretion. I mean, it's one of those things where it's not really, there's not like a hard and fast rule on it.
Ken, appreciate your insight on all this stuff and answering the listener questions each week here on Criminal Law 101. To contact for Ken Eulo at Smith & Eulo, again, Taco Bob.
SmithandEulo.com or Ken at SmithandEulo.com.
All right, Ken.
Good seeing you guys.
All right, man. We'll talk to you
Happy
next time.
holidays,
Same to you.
brother.
Merry Christmas, brother.
Lynch and Taco.